The
Executing court.
The
of
executing
Deputy
court.
Commissioner.
of the Deputy Commissioner, East Siang District, Pasighat, whereby the execution petition being execution case number 01/2023 filed by the petitioner for execution of the KEBA decision dated 4/4/2022 has been dismissed as not executable. Uh, Issue notice, call for the record. The notice and issue notice returnable by 4 weeks. Call for the record. So the petitioner shall take steps upon the respondent by a registered post which aiding within 5 days
5 days.
from today. List this matter after 4 weeks.
Page number 17.
Having regards to the contention made in the petition from the it is provided that in the meantime, the operation of the impugned order dated 15/6/2023 passed by the Deputy Commissioner East Siang District, Pasighat, shall remain stay till the next returnable date. Okay.
Repeat that.
Yes.
My lordship, this is bail application. And this bail application is being filed after being rejected by district and session court UTI.
It was rejected.
Yes, Your Honor, my lordship. Kindly see the page number 26. It is a FIR copy.
Page
26.
26 is a rejection order.
No, FIR copy, and rejection order is in page number 18.
26 is FIR.
Yes, Your Honor.
7%. And the rejection order is
Page number 18. Your Honor, there are 6 accused was there.
Yeah.
6 accused was there. Out of 6 accused, during this rejection of bail order,
when it was rejected.
on
It was rejected on
9th.
9th.
Yes, my lordship.
So-
2 of accused was released on that day by the honorable court.
Okay, 2 accused.
Was released on that day.
Okay.
And
That day.
yes, and I
So
have
your bail application has been rejected.
yes, Your Honor. And 2 more was also released. Just I have heard about it, but I do not confirm. There was 6 accused was there, and now it is being heard that the accused person victim they were friend, and after release from the jail also still they are friend. And here, Your Honor, that this both the applicant, one is security guard and another this bail application. Another is also a student of class 12. So, Your Honor, this security guard with regard to bail application number 43. He was only implicated on the ground that they were fighting, and this security guard, he go there and try to appease the
So-
situation.
So the accused and the victims are friends,
Yes, Your Honor.
but in the FIR says that unidentified person.
Name of the accused are mentioned here, however.
No, that only says later on.
And the affair was
letter-
lodged by the elder brother of the victim.
Accused person identified after inquiry. Accused person, after inquiry.
Yes, Your Honor.
The
This
victim-
affair was lodged by the victim of
After
the.
inquiry, one accused person was identified, and these one accused person revealed the name of other accused. They are total stranger.
No,
How they are
Your
friend?
Honor.
When they have
This-
become friends.
Your Honor, this affair was lodged by the elder brother of victim.
Anyway, so your bail was rejected on 9th.
Yes, Your Honor.
So what is the new ground you have taken this time before this court?
This time here that Your Honor, kindly see the page number. Can you see the page number 21 and 22?
What is that?
On the date of that bail rejection, that the mother of the accused person was suffering from cancer and she has been transmitted to CMC Vellore.
But this was considered by the Learned Trial Court also while rejecting the bail.
No. This was referred after only bail was rejected.
Then only she was detected.
Uh,
Anyway, so
and Your Honor, second ground is I
on
came before
9th itself, the case diary was probably produced. Now over and again calling the case diary.
Lordship, this medical is, this recommendation date is also 8th, Lordship, and this order was passed on 9 prior to one date. So
bail
Then-
application was already filed before prior to this, and Your Honor, therefore this was not annexed in the bail application.
You see, for filing subsequent bail application also, you have to satisfy that these things was not considered or it was not placed before the Learned Court where the your bail application was disposed of. But then you see subsequent filing of the bail application doesn't acquire by that way you doesn't acquire right to be
Yes.
released on bail only because you have filed subsequent bail application
And Your Honor,
unless the situation has changed.
yes, Your Honor, in this situation, Your Honor, I'm trying to convince this honorable court that that this accused person, he was taking care to her
The
mother.
same thing was considered by the trial court. What I'm
Here
saying
I
is
have
this.
not, Your Honor, submit this
Why you did not submit that?
because Your
You
Honor,
kept
No.
some of the good points to argue
Your Honor.
for the High Court.
at that time, Your Honor, that the cancer was not found,
Hmm?
and on that cancer was not detected by the medical officer, but cancer was detected only after filing of the bail application, and that the mother of the accused person has referred to the CMC Vellore on 8th of this month, Your Honor. And there is no one to take care to her mother. And his father is applicant here. His father is old person, and he do not know anything about the outside of the wall. And secondly, Your Honor, one of the accused person was released that he was not by stating that he was innocent in the case. Here, Your Honor, I have a humble submission before this honorable court that I am also innocent in this case, Your Honor. Most importantly, Your Honor, that
Open instruction.
Lordship.
There it appears there is some material against him. So just. Anyway. Okay, Mr. We'll fix early date, huh? Learned counsel for the petitioner. Para. This is the bail application on section 239 of the Code of Criminal Procedure 1973, praying for release of the accused Gungtesh Singhi,
Yes, sir.
who has been arrested in connection with the Chimpu PS case number 25, 2024 under section 341, 307, 34 IPC. So, call for issue notice, since Miss returnable by next week.
Next week, Lordship.
By when is the court? 19th?
22nd, Lordship.
Huh?
22nd,
32nd, okay, by 20,
22nd and 23rd, anything.
23rd, no? Since Ms. El Hage, learned additional PP has accepted notice. No formal notice need be issued. So on the next date is fixed above, the learned ADBP shall produce the scanned copy of the CD along with the status report of the case. So list it again on page. Oh, sorry, 12. Not 12, 22, huh? 22. Okay.
Your Honor, that the
Can I use the same FIR?
Same
Same FIR, I
Okay,
use.
same order, similar order.
Right.
My lord,
Yes.
matter may be pass over for time being, man. Leading counsel, Mr. Deepangan is
Okay.
at court number 1.
Time is, huh?
May I please on?
Yeah.
Now, this criminal petition has been filed by the petitioner number 1 and 3, who are the husband and wife, and the accused persons in FIR number 18 of 2018 in Bomdila PS, case number 18 of 2018.
I think this is victim need to be made party. You have been made, no?
Victim has not been made a party, Your Honor. In the lower court, victim has been dropped by the prosecution as a witness because she was not appearing for the past more than 2 years. So
Victim has been
notices,
dropped.
yes, Your Honor. Notices were being issued
Have
to
you
her.
annexed the order?
Yes, Your Honor.
Where?
At page number 66, the last page.
Page?
Last page, 66.
Yes.
If I may read one. Accused persons are present and have been informed of the next date. Learner PP so and so present. Summoned witness PW Ms. Sia Karkaria is absent. Report is received regarding execution of BWA issued against the PW Ms. Sia Karkaria, stating that it has been duly executed. However, she is absent today without steps for use. Learner PP submitted that if the PW Ms. Sia Karkaria is not appearing even after execution of BWA, she may be dropped. Heard, it appears that PW Ms. Sia Karkaria is not willing to prosecute the accused and stands as a prosecution witness in this case, as because she would have appeared or taken steps before the court after execution of BWA. Accordingly, PW Ms. Sia Karkaria is hereby dropped and issue summons to PW so and so on. And in this case, Your Honor, all the other PWs are all hearsay witnesses.
Who is the informant then?
Informant is a member, chairman of the
Informant also
CWC.
dropped.
No, informant is present and his statement, his deposition has also been recorded.
Make the informant then party. Victim in any case is a minor.
Yes, Your Honor.
So make the informant party. You have to.
Your Honor. I'll
If-
file an
if
application for
informant
reading.
has also already deposed.
Pardon? Your Honor?
Evidence of informant has.
Evidence has already been deposed.
Okay. That's
And
implicated, no.
so no, so what he's saying is whatever he has stated in the FIR has been stated on the basis of what the victim has told to him.
Victim stated,
Yes, sir.
okay, so that is.
So that is also hearsay.
That is- that
all the
means
other
what he
evidences-
stated is correct,
Yes, Your Honor.
but
If-
then they need to be made party in the question petition.
I will,
They need to be given an,
Yes, now it's become obligatory to make, but
yes, that is obvious.
its incumbent is CWC chairman.
Oh, CWC.
CWC
Yes.
chairman.
I'll file an application for impleading him.
Okay.
But Your Honor, on this case has been fixed on 22nd of April for the evidence of.
22nd
22nd of April.
April.
And this coming week is, the vacations will be starting from Monday.
So April 4, evidence of,
All the PWs, 3, 6, 7,
let it
9.
continue till then.
Okay.
Okay. Is hard miss. Her name, huh? I've also
P.Y.
heard
Bachchan.
Mr. G. Tado, learned additional PP, government AP staff, huh? The, huh? Just a minute. This is an application under section 482 of the Criminal Procedure Code 1973 for quashing of FIRs number 18, 2018 in GR case number 01, 2018, Bomdila under section 42, 511 of the Indian Penal Code, read with section 23 of the JJ Act 2000 and 2000 and criminal proceeding arising out of FIR number 18, 2018, which is pending trial before the court of the Chief Judicial Magistrate, Bomdila. The informant has not been made as a party. Just a minute, sir. The learned ADPP pointed out that the informant has not been made as a party, which is an obligatory. No, sorry, not been made as a party in the petition, huh? This, the learned counsel for the petitioner prays for some time to file additional affidavit for implement of the informant as a partner, respondent in the criminal petitions. The prayer is allowed. So list this matter after 2 weeks.
Obligation.
Maybe.
Four.
Maybe. I'm sorry, when I was on left in court number.
Yes, yes, no problem.
The new trend now, my lord, is going on is, people get into a relationship, my lord. They stay together as husband and wife. So somehow the relationship breaks down, charge of rape. 2017 December, the relationship starts, the petitioner and the prosecutor. March 2018, they start staying together. By July 2019, their relationship breaks down and they file this FIR. My lord knows what the Honorable Supreme Court has held on this. If there is a conscious decision made at that time, even if there is a promise of marriage, once that conscious decision made, there is no question of my lord 376. Other sections, my lord, will argue about in that term. But how can I be, my lord, charged in 376? The two materials that was before the learned trial court was the FIR and the ditto 161 statement of the document. Your Lordship will kindly have the FIR at page 16.
Yes.
With, this was obviously drafted by a lawyer. He has tried very hard to somehow fix me. With due humble submission, I would like to inform before the good authority for necessary action against the aforesaid accused person that on 17th of December 2017, for the first time I meet accused person at Panyo River Festival at Yajali. An accused person used to frequently call me and
So-
many
so
of
there
them-
was a proposal for marriage,
Yes,
and that is why they started staying together.
yes.
Okay.
So where is the question of I have been now charged, my lord. Charges have been framed against me under 376. Other sections, my lord, we will take care of later. But how 376, my lord? Supreme Court is very clear on that. So, shall I read?
It's fine.
He used to frequently call me and many occasions proposed to marry me, informing that he's a widower and single, and I have to take care of his 4 children born out of his dead wife. No deceit. I have informed that I am a widower. I have 4 children.
It appears that on the promise of the
Yes.
of marriage, they
Yes.
started staying together.
Yes. But the
Okay,
Honorable
but
Supreme
then-
Court has says, even if on the promise of marriage, you made a conscious decision,
Yes,
that
yes.
does not amount to 376.
Right. Mm.
That is the law, my lord.
Mm.
So where's the question of 376, my lord? And she also is a divorcee. It is not that we both are young teenagers or something like that. She is a divorcee.
417, yeah,
Yes.
okay, 427.
The accused person constant proposal for marrying me with sweet talk made me believe that he's a good person. And finally, I agreed this proposal. My lord will kindly see. I agreed to his proposal. That is her decision. The accused person asked me to stay with him in A sector and forced me to have sexual relationship with him on promise that he will surely marry me in a formal way as per customary law. With hope that the accused person will keep his promise to marry me, I could not resist. That's her own statement. The accused to have sexual relationship with me and on his promise and behest, I stay at his house located at A sector, Itanagar, 15 March 2018. So after this, where is the question of rape? This is her own admission. She says, on my
This is an application under section 482 of the Code of Criminal Procedure, 1973, praying for quashing and setting aside the final form report dated 25/2/2021, submitted by the eye of the case in Women Peace Itanagar against the petitioner under section 376, 417, 427, 506 of the IPC, and for quashing and setting aside the order dated 12/3/2024, passed by the learned Sessions Judge UPR in Sessions case number 12/2023, in ETA WPS case number 77/2019,
yes.
by wherein charge have been framed against the petitioner under section 376, 417, 323, 427, and 506 of the IPC. Stop. Code for the issue notice, returnable by 4 weeks. 4 weeks will be within May only.
Yes. Fine.
4 weeks. Call for the scanned copy of the.
We'll take steps upon the respondent number 2.
Since Mr. G. Tadao appear on behalf of the state respondent, no formal notice need be issued against the state respondent. However, the petitioner shall take steps upon the respondent number 2 by a registered post with AD within a week from today. So, list is matter after 4 weeks. The interim prayer shall be considered on the next day
Obliged.
On the receipt of the records.
on receipt of the record.
Okay.
Yes,
Lordship, I'm appearing on the behalf of UDECA petitioner here for the United Indian Insurance Company. Counsel today cannot appear due to his medical treatment. He's out of station and he's
Counsel
already
is?
filed. Lordship,
counsel is,
he's under treatment out
Okay.
of his station and he has already filed a leave of absence.
okay. So when do you want,
After vacation, Lordship.
whether the other side appeared? No, not yet.
No, none has responded.
Okay. Miss Didi Long, Line Counsel for the appellant. So the Miss Reno, huh? No one appears on behalf of the respondent. Copy, it appears that has been received, huh? Okay. Is prayed for by the Lana Council for the appellant. List this matter after,
After vacation, Lordship.
means after 2 weeks.
Vacation, after view vacation, after
Vacation is only, yes, after 2 weeks.
2 weeks.
2 weeks, is it okay? Okay.
God bless you.
Lordship, here in the matter, yes, Lordship.
Yes, who
May I please, my lord, we're arguing matter together. It was handled by
Yeah.
them and we're additional counsels. No, we will be arguing together and I'm leading the argument. My lord, this Bell AB matter, my lord, today only we have filed one IA. There was a condition when this interim order was passed, my lord, that I have to deposit 2 checks. And I have also stated before the court that these 2 checks have been deposited to in another case before the IO in an infile matter. So I'm not in a position to give the check because it is really in the custody of the learned CGM infile. I cannot again withdraw the matter. So there's another complication. And moreover, my lord, this particular condition that to give the check so that my interim will continue, on that ground, we have filed one IA to modify the order because it's impossible, my lord. On one aspect that this will be in the judicial custody.
there is an order. Do you have the Xerox copy of that check?
My lord, that I have made a prayer that if your lordship is pleased, if your lordship direct me to submit a Xerox copy of that, then I can do, my lord. Just before getting your lordship's permission, the check also. I have
What is there in this case?
that I have made a prayer. In that case, if your lordship permits me, I can hand over the Xerox copy of the check. In that particular case, I have given that this thing statement also. And in the event your lordship permits me, I can hand over the Xerox copy of the check.
So then if he has already deposited before the police, given before the police. he
My lord,
cannot-
my lord.
He cannot.
Lordship, here, Lordship, they have been, Lordship, evading the Lordship, they have not, Lordship, totally, Lordship, they are misusing the interim protection, Lordship. Since 2024, Lordship, he is
You
in,
are asking for
Lordship,
same check, which they have already given it to the another police station.
Lordship.
How would they collect? It's not possible again to present
No,
the,
Lordship, they have, they, Lordship, they admitted, Lordship, they will produce, Lordship, in the order, the Lordship, dated, Lordship, kindly, Lordship.
by which order you are asked to deposit these 2 checks?
Lordship, first order, Lordship, 23/1/24, they have granted interim protection, Lordship. Again, 5/2/2024, in the interim protection also, Lordship, they have the condition, Lordship. They appear before the IO of the, within the 7 days. Since then, they have never appeared before the IO, Lordship, and they cooperate the investigation of the case and not directly make any inducement, increment, or treat to any person, Lordship. In the death bail condition, they have been given interim protection. After that, 5/2/24, again, the CD was called for and I prepared the CD and Lordship, in that order, it is mentioned that petitioner appeared before the IO for the recording statement, but he has copied, but the interim in absolute terms, but the Lordship, in that CD Lordship case diary, it is submitted that in the case diary, the withdrawn check bearing number 75108 is missing from the custody basis. Apart from that, Lordship, 7 numbers of check
Where
are
you-
also missing.
Where are you reading?
Lordship, this is the order dated 5/2/24. 24 Lordship. After they have given interim protection Lordship, they appear before the IO, but they have failed to Lordship deposit the missing check as well as the 7 under blank checks Lordship.
Custody of the petitioner, apart from 7. So this is talking about one. Withdrawn check bearing numbers.
Lordship.
Missing. Just a minute, huh?
Yes, Lordship.
We are talking
Again,
about 2 checks by counsel for the petitioner. 3 weeks time to deposit 2 numbers of check, though he was directed to deposit 7 numbers.
Lordship.
So altogether, you were just a minute. You were asked to deposit 7 numbers of checks,
Lordship.
which was found missing from
My
the.
lord, my humble submission is,
Hmm.
so far I'm concerned, it's only about 3 checks.
Okay.
One check I have already presented and it was honored.
Presented
Now,
where?
only 2
Before?
checks. When
One,
others checks
one
are
check
done,
before where? One check deposited where?
One check I have deposited in the bank, my lord, and it was honored.
Okay.
Now 2 checks
Ah.
are remaining with me.
Uh,
3 checks were given to me, not 7 checks. And from, I don't know from where again they have brought up these 7 checks. How can I be imposed when I have admitted, well, 3 checks were given to me in lieu of 25 lakhs. I have withdrawn 7.5. 2 checks, if your lordship please, I'm ready to hand over the photocopy of the check, photocopy of the check. But when
that was the 2 more check were not yet presented
check
before,
with me.
not yet presented before the.
the
Bank.
two more I have because they have filed this case. So I also filed a case against counter. I have also filed a counter FIR because I have been given this 3 check in lieu of 25. And after I have withdrawn this again, they have filed a case. So I have also filing file.
Okay, no,
So
no,
these-
just
these
my
2
query, 2 check
have been given to before the court.
Fully-
I have submitted.
court.
I filed.
It was not yet presented before the bank.
But I didn't. I didn't.
Okay, so it was already, it is before the court there.
Before the court. But I also have met a statement in the order also. But again, they are saying for another 4 checks.
Hmm.
Another 4 checks, which was not with me. And now they are forcing me to produce these 4 checks also. And I have appeared before the IO 5 times. And every time, whenever I appear, I will insist that to hand over another 4 checks. I have admitted, okay, 3 checks were given to me, 1 I have presented, 2 checks are with me, which I have submitted before the court. If you lordship.
So they are apprehending that this 4 check
Are also
also.
with me, my lord,
Ah.
on the apprehension, my lord. On
So
apprehension.
Lordship.
Just a minute, just a clarification one. So against this 4 check, is there any complaint or any before the bank that?
No,
not to
no,
entertain-
Lordship, nothing in there, Lordship. On the record, Lordship, since
No,
the
no,
Lordship.
what I'm saying is
Yes,
after coming to know that you have the 7 numbers of the checks are missing.
Lordship, may I, Lordship? Because Lordship, after that, Lordship, when once the order has passed, Lordship, on the 5/2/2024 to submitting that number missing checks, Lordship, again 23/2/2024 after 3 with this matter again come up, Lordship. Here also, Lordship, the petitioner did not submit all those things, Lordship. They have submitted that they are required to, Lordship, here, Lordship, the order, Lordship. The petitioner was granted 2 more times to submit the said
Order
check,
dated-
Lordship.
order dated-
23/2.
Okay,
They have asking for the time for Lordship to submit the said check before the IO. And the counsel for the petitioner submit that the said checks were handed over to IO of the case registered by petitioner impar Lordship against the informant given, Lordship. Why they should send it to the impar Lordship where that check is needed here, Lordship? And then Lordship, again, Lordship, petitioner counsel undertake the direction passed by the court dated 5/2/24 shall be complied with by the accused and the checks in question shall be handed over to the IO of the case, Lordship, within the period of 10 days. They have Lordship asking for the 10 days time. And that is the
Where,
updated
where,
CD.
where?
Here, this on the same order lordship, that is 23 to 24 lordship. On the next page, page 2 lordship. And when the updated case diary was called for lordship, I have produced the updated CD. The interim passed lordship. Here the court was observation was that lordship. The interim order passed unless it continue till the next date of listing. However, further continuation of the interim order shall depend on the conduct of the petitioner in assisting the investigation as would be revealed from the updated case diary and the action required to be taken by petitioner on the next date. This is the order lordship. And again, they have lordship on 11/3/24.
Just a minute.
lordship.
So here it appears that you have undertaken that the order shall be complied.
Lordship. They have never appraised this kind of lordship
And then the check in.
additional affidavit on that day
Check in question
lordship.
shall be handed over to the IO of zero. So whether have you complied that one?
Lord,
You yourself have submitted.
my lord, I humbly submit that. When this particular matter was filed before this honorable court, it was brought to the notice of this honorable court that on 16/1/2024, I have filed a case against fraud. That was then back to 16/1/2024. So there, so for this submission.
But then why you have undertaken to before the.
That may be, I don't know, some communication.
So yeah, just see
No.
23 too.
My lord, I agree with that, my lord. If your lordship is pleased, my lord, on the day after the interim order was passed on 5/2/2024, order dated 5/2/2024, it was not on from my side that I will submit the check, but on the other hand, it is, I'll just read out, on the other hand, Ms. Hage, learned additional PP submitted that some more time may be given to the petitioner, enabling him to.
No, lordship. I have not submitted on behalf. They only lordship time lordship.
My humble submission.
It's a wrong submission
So for
lordship.
these 3 checks are concerned, my lord, I agree that 3 checks were given to me. One on being present that has been ordered by the bank. 2 checks are lying, which I filed my case on 16/1/2024 at Imphal, my lord. If your lordship permits me, I can get a certified copy of the whole entire certified copy of the petition which I have had before the Imphal court along with the check and can submit before this court.
Lordship, this
My lord,
immaterial
what-
lordship in this
what-
bail application lordship. This is AB lordship.
What aspect of the matter? If your lordship is pleased, I humbly tell your lordship to page number 17 of my bail application, and things will be very clear for me. This was a series of FIR that I mentioned in the FIR, my lord, page number 17, my lord.
Lordship, after that,
And
again
this-
on 11/3/24 lordship, they have again lordship took
It is-
lordship
wait,
2
wait,
weeks,
wait,
3 weeks
wait,
time
wait.
lordship.
Things will be very clear after perusal of this particular FIR to, it says to the official interest police station and page 17 of lordship from FIR against so the participant. This is to inform you that one, Hamon Pudananda of Imphal has fraudulently withdrawn rupees so and so. Now, Pudananda happens to be my friend. I was shocked to receive a message from the bank that some amount has been withdrawn without my knowledge and permission by a person unknown to me and having no any business dealings with me. Number one, Punanda is my friend. I have got a dealing. Now, next para. I strongly suspect involvement of Sri so ex-general manager, is a checkbook was under his custody and a check number 795, which amount was withdrawn found missing when he returned the checkbook on August 8, 2023. The checkbook was returned on 8 August 2023, and he says that it was found missing, and he filed this FIR on 8/1/2024 after the check has been withdrawn. After a gave up, my lord, it was in August. August is gone, September gone, October gone, November gone, December, and January. I was told to withdraw this amount. Now, after I have withdrawn this case has come up. So after about 6 months. So why, when these checks were missing in the month of August, when it was handed over to him and it was found missing, and there was no question, there was no FIR. Now after dismissal from service and also the following page of checkbooks were found missing while checking the time of handing over after it was handing over, it was found, and what was the explanation given by the complainant, my lord? No suggestion given here whether they discuss about this. Now, check number so and so. In view, I'm afraid that all these above missing checks may be misused again by the same fraudster in future, as the checks were neither returned to me or is able to explain for the missing. When it was asked, it was never discussed. Now, after 6 months, they have come up with this complaint. No, my lord, I respectfully take, my lord, again to page number 19. It was another file before the branch manager by his son. Now, my lord, page number 19. I'm an accountant holder of your SBI branch manager bearing number so and so. Now the son becomes the account holder. This account was recently transferred from original SBI branch Hapoli to so and so. My lord, this is to inform you that the checkbook was under the custody of one Sri so and so during the period from March 2000, who was employed as general manager. He had left the service in the month of July for safety reason. As the checkbook was not handed, I intimated bank to block the check withdrawals. Now, if at all this is true, that in the month of August, if some requisition is made to the bank to block these checks, how could it be presented? How could it be honored, my lord? So this is totally false. Now, for safety, as the check was done, I intimated the bank to block the check withdrawals, and it was blocked. The moment check is blocked, my lord, lordship
It was
understand.
blocked.
Now, for safety reasons, if the checkbook was not handed over, I intimated the bank to block, and hence it was blocked. So, whether a blocked check can be withdrawn, my lord? The issue lies here, my lord. The check was blocked. Now, the checkbook was returned to me on 8 August on my several requests. The following pages of checkbook was missing. Now, even the son has not said anything. The father said that it was written to him. The son said that it was written to him, my lord. The father said that checkbook was written to him. The son also said that the checkbook was written to him. Now, as the checkbook was handed over to me with good faith, I intimated back again to unblock the check. Now, let's see another version. As the checkbook was handed over to me with good faith, I intimated the bank again to unblock the check service, to which the branch manager of Old Zero said that the old checkbook cannot be reopened back. Now, if the branch manager has given the assurance that the check books cannot be reopened and this particular checks mentioned will be blocked permanently. Now, a new fresh checkbook should be applied, and accordingly I had applied. Now, the whole story is that these checks cannot be used. Let's believe for the time being, assuming that they have given this to block the check, and now after it being handed over, the branch manager, no, these checks are all useless again, because once it is blocked. Only new checks has to come. Now, with these two verses, my lord, how far will you go, and that will allege me that I have presented the check. If it is the version of the bank manager that once the check is blocked, it cannot be used, and he has intimated the bank in the month of August. And this FIR was filed, this information was given on 11 January 2024, after a gap of 7 months, and now they are charging me with this another 7 checks, another 4 checks.
Lordship,
Therefore, my lord,
Lordship, in this withdrawal, Lordship.
Therefore, my lord, therefore, we have filed this IA for modification. And if your lordship permits me, and I have also filed my complaint, which I have annexed here in page 26. So we need a very detailed hearing, and everything has to be called for, even from the bank, whether any such applications are lying before the bank. And if no applications are lying, they are cheating. The complainants are cheating, my lord.
May I, Lordship?
Just a minute. Now, it has withdrawn the above amount. I strongly suspect the involvement of so-and-so.
How can, if it is blocked, my lord? If the bank has given that this check cannot never be used again.
See, the informant himself stated that I intimated the bank to block the check withdrawal, and hence it was blocked.
Lordship.
Even if the check had already been issued, so since it is blocked, it can't.
Lordship,
And thereafter also, you see, have you seen just page 19? You just open page 19, what we had just read.
Lordship,
Have you seen?
Lordship, I am saying
So
that.
under the circumstances, so why we are insisting for these two checks.
Lordship, may Lordship, in the same line, Lordship, there's a second paragraph, second last Lordship,
Hmm.
but one person named Mr. Hanom Purnananda of Impal has record revealed in the account statement by check bearing number 759108, which the Lordship, the number of check Lordship, which is missing Lordship, is the same number Lordship, second number Lordship, 759108 has withdrawn rupees 7,35,000 only from my account number this last night Lordship. That is on 10th January. That's why this letter is, they have Lordship 11 January. This letter dated is 11 January. This day before last night only, this check bearing number is withdrawn Lordship from this complainant account Lordship.
That is true. That is true.
There's a Lordship.
That is true.
Admittedly, one check they have withdrawn.
No, Lordship, that's why Lordship, this number out of this missing Lordship checks, Lordship, one is withdrawn Lordship. That's why Lordship, other checks is still not available. He's with him Lordship. So ascertain that Lordship.
Out of this, you said you have lost
Seven
seven
checks.
check is missing.
Lordship,
Out of that, he's admitting that three check
Lordship,
and three check were given to him.
Lordship.
And out of these three check, he has presented one check amounting to rupees 7,35,000.
Yes.
And
That's
two
it.
check not yet presented.
Lordship,
And in the meantime, because one check we already withdrawn,
Lordship,
7,35,000.
Lordship,
After withdrawn, he has written and then the check blocked now.
Lordship.
Can't withdraw. And in the meantime, they have also filed
An FIR
complaint before the court.
before the court.
Before the court, and that check has already been presented in that case.
Lordship, they said the
So,
record is not
what-
there, Lordship. They have verbally they have submitting Lordship.
No,
Lordship, the past Lordship, several Lordship
let us-
occasion.
let us ensure
Lordship.
He's ready to deposit, he's ready to submit
Lordship.
all those documents. also.
Lordship, this
Right?
is the Lordship past
Certified
several
copy,
several
I'll submit
occasion
the-
Lordship. They have Lordship
So there
given
was
the
some,
enough time Lordship. This bail application, this administrative bail Lordship. They are Lordship ample of time they have given Lordship earlier occasion. On the Lordship, may Lordship order Lordship 11
Try to understand.
Lordship.
So this order says that we check, deposit of check, you are insisting for these two check to be deposited. So these two check, what is submitting now is that these two check have already been deposited before that court in Manipur, Imphal. So
Yes.
that they are ready to present this check, copy of this check, which has. already
Lordship,
been
that is
deposited.
already Lordship. They have submitted before the court. The court has have already granted enough time to deposit Lordship here Lordship. Lordship,
No,
the
I-
last
I
order
was
Lordship.
even- no, no, not
Kindly
for
Lordship,
the-
11
the
Lordship.
check.
Kindly Lordship, 11/3/24 Lordship.
I was-
Order dated
I was
Lordship.
asked to
Here
deposit
Lordship.
the check.
Order dated
Now-
kindly Lordship.
Let us-
Order dated Lordship 11/3/24 Lordship. After that, here
11?
granted 11/3/24.
What is that?
Here again, Lordship, the counsel for the petitioner prays for the 3 weeks time to deposit number of checks through he was directed to deposit seven number of checks for the time being the pay of the petitioner is allowed. Again, they have Lordship seek permission to time for the deposit of the check Lordship. They have never applied before the court that they cannot do this thing and they cannot Lordship apply that
Just
Yes,
read
sir.
the entire sentence of that paragraph.
Lordship. The non-counsel for the petitioner prays for 3 weeks time to deposit 2 numbers of checks
Two
Lordship.
numbers.
Lordship. So he was directed to deposit 7 numbers of cases. He was directed to
No.
deposit.
Though he was.
Lordship.
Though
Lordship, he was-
directed to deposit 7. Now he's saying that 2 numbers of check to be
Lordship.
deposited. It took time. Now he is ready to deposit the copy of the said check. It says that it cannot be used because it has already been deposited before the court.
Lordship.
And even if it is not deposited before the court also, it cannot be used because it is already blocked.
But Lordship, they did not comply the order of the court Lordship.
Okay.
Till now, they did not appear
Now-
before the
now they
IO
are-
Lordship.
They are seeking permission to deposit or submit the copy of this
Photocopy.
photocopy of this check.
Check before
Mm.
this court.
Which
Or
has been
before the
submitted.
IO.
So why don't you submit the entire, the documents showing that this check has been deposited before the court?
Yeah, I
Not
can,
only
I can give
not
the
only
entire
Xerox
certified
copy of the
copy.
check, but
I can give the
check-
entire certified copy of the complaint petition I filed before the court.
Okay.
I
So
can give that.
That will satisfy.
That will say, and my lord, my humble submission, my lord, that another, like, sometime after the election may be given, I'll give the entire certified copy.
No,
of
Lordship,
the
they
petition
have
filed before
already.
Before the court in Imphal, and now to submit the check, the original copy to check, it will be impossible because yes, I have already submitted and I cannot submit it.
It is
And
best.
my lord, and one humble submission.
What complaint? Complaint against?
My lord,
Huh.
the case is, that's a different background. 25 lakhs, the complaint has taken 25 lakhs from me. That's, and after,
Security deposit.
no, after that, he has given me
That
3
is-
checks.
that
I
is
was
security-
running on lease this particular resort.
Hmm.
So on giving, by paying 25 lakhs.
Hmm.
After I was terminated, that I was asked not to run, this 25 lakhs, which I have paid, was given by way of check, 3 checks.
Hmm.
With an understanding that I should present it on a favorable date when the money is available in his account. My lord. Now, so for page 19 is concerned, his son said that on 8 August 2023, that checkbook was given, and on the same day, he went to bank and he blocked all the checks. He blocked all the checks. That was dated 8 August 2023. Now, after I have handed over the checkbook, the version is that again he went to the bank to open these blocked checks. Now the bank has said, no, yes, you have already blocked, we cannot open it. You have to use by new checks. Now, but these particular blocked checks, how could I again use in January 2024, my lord? So there's no link between this complaint and this narration, my lord. So something is missing, my lord, even from the complainant side. So
No.
I'll submit the entire
What
certified
is the
copy.
complaint for that court? What I'm asking? Complaint is against these.
Against complainant, because for filing false allegation against me, because after giving the check,
Okay.
and now he's again saying that I have withdrawn the check without his permission. So I presented these 2 checks. before the
Now,
court.
according to you, you're entitled for another 2 checks.
Lordship, they are just,
25 lakhs.
I have raised the issue also that I still have to get another 18 lakhs from him.
Hmm.
Some approximately 18 lakhs, because only 7 lakhs something I have received. Some 18 lakhs still I am to get. Therefore, I have also filed a case for filing this false allegation.
So you're totally denying it, another 4 check is not with you.
Totally, these 4 checks are not with me.
So-
I admit with these 3 checks. I
But then
admit.
even this 4 check, you try to understand,
Lordship.
it cannot be withdrawn. Try to understand.
The Lordship, they think I understand. Lordship, at least Lordship, they have asked to submit at least 2 checks, Lordship. They could not submit the 2 checks also, Lordship.
That is what he is submitting.
They seem to pass
That
several.
2 check
Yes.
has already been submitted before. That why you have submitted that check before?
That's why Lordship passed several. Then
Because-
Lordship,
And that check,
Lordship.
the entire document based on which they have also filed counter complaint before that court, they are ready to furnish
Certified copy.
certified copy of those documents. So I think so under the circumstances, insisting for these 7 check or say, okay, 4 check remains of course unsettled. With regard to the 3 check, which he admittedly
Checks,
has
2 checks.
admittedly
Yes,
has been,
ma'am.
of course, given by you, they have used 1 check and 2 check before the court, that court, the original check.
The original,
And on a copy of that check, they are ready to deposit before this court.
yes.
To satisfy this
Photo.
and comply, you have brought that entire copy today.
No. I have to apply for.
This, this.
Here I have come only to seek for
Because
seeking
you
your
have
permission.
undertaken earlier also.
Lordship,
Seeking for your
they-
permission.
Could have come
No, no.
prepared with.
That is, I have filed this. I have seeking your lordship's permission.
Is it ready? Not yet.
IA is for seeking permission from your lordship to submit
I-
photocopy.
Lordship, IA
Check.
for the Lordship, they have filed the IO for the Lordship, for the modification of the order, Lordship. How can they file the IA for modification of
Yes,
order,
and
Lordship?
I'll come. My lord, your lordship, please grant me. I'll.
How
that
can
why-
they
why-
sub,
why
that
this
they?
IA? Because this
No,
is a
no, Lordship,
condition
this
which
cannot be done,
fulfilled with the-
Lordship. They cannot file IA for the modification of the order, Lordship, because that by this order,
So.
they have
so
granted the interim
with
protection.
With regards to this 4 check, and then since the case is still under investigation,
No,
we'll
sir.
find it out. But then with regards to this 3 check, admittedly that they have already, they have taken and then 1, they have presented and then availed the money also, withdrawn the money also. And then 2 yet to be, sorry, 2 yet to be withdrawn, but then it is in before the court and they are entitled 18 lakhs.
Yeah, my lord, approximately.
Okay.
So
anyway, so you,
I'll
you
furnish a
file-
certified
you
copy.
furnish the certified copy of the entire document to show this court, because you have undertaken, and I don't know, see, probably.
Yes, my lord, because there was some
There has been some
communication, yeah.
miscommunication, and because of miscommunication, and because of that, I think that your advocate here is taking time to produce.
My lord.
Lordship.
So
Mm,
there,
it is
then
there.
I,
So now you, two check is with you only.
two check is with me, but with the custody of the thing. I
No,
have
no,
deposited
no,
before the
copy
court.
of the two checks.
No copy of the check, I have to get a certified copy. Certified copy of the two checks.
When will you file that,
Uh,
the documents?
Document, my lord, I'll
Copy
apply,
of these two checks.
after election, I can place it before your lordship, after the election. 2 weeks time, please, because it has to come from Manipur.
So this, IA is only seeking permission.
I is seeking
No,
permission.
Lordship, I have a modification, Lordship, order modification. IO cannot be admitted, Lordship, at this stage, Lordship, kindly, Lordship.
I is for seeking permission from your lordship to
Mm.
produce a photocopy. And moreover, because in this particular order dated 5/2/2024, something is impossible so far I am concerned.
Kindly, Lordship, the IA, Lordship, paragraph 17 may kindly look into, Lordship. Kindly, Lordship, paragraph 17, Lordship. They are condensing the IA, Lordship. Paragraph 17. Paragraph 7, may I, Lordship?
Yeah.
Yeah, Lordship, the petitioner begs to state that he cannot part with the original two checks and hand over the same to the investigating officer of the present case, as handing over the original copy of two checks to IE of the case would jeopardize his process of recovery his legitimate dues from the informant. Therefore, your lordship humbly is requested to modify the order dated 5/2/23 and 23/2023, so that the effect of your statement made herein above. How can it be possible, lordship?
Try to understand this.
Lordship.
They have also filed counter complaint.
Lordship.
And in that complaint, they have deposited this check. Is it so?
Yes, my lord.
They have already deposited, this is already under the possession of the police or in that case. So under the circumstances.
They have never
cannot
appraised
be
this.
original.
They have never appraised this before this court, lordship.
Hmm.
They never, but they only, lordship, they only seek time to deposit the two number of checkbook before the IO, lordship.
So during the
On the basis-
pendency of this case only you have.
I have appeared 5 times before the.
No, during the pendency of this case only you have filed counter complaint.
I have placed it before the Superintendent of Police on 16/1. 16/1, that my lord will find in the last space of my petition. Thereafter,
And this,
my lord will find the last space, Annexure 3, page 26.
hmm,
Page 26 of my bail application. So when they have failed to register a case, I file under 156(3) before
Page?
this. Page 26.
what is this?
16/1, I have filed about this. I have given all the entire narration before the Superintendent of Police.
Where do we find that you have deposited that check? This is against,
This is to the police against Agemat. Now, as no FIR was filed, I have filed 156(3). Thereafter, as
hmm? Just a minute.
Well, even I have admitted that 3 checks were given to me, even in this petition.
Mhm.
Now,
Where
when
do
this,
we find, can you
when-
just read that portion where you have stated that you have
I have admitted here that para 3 of page 26,
para 3?
para 3,
Okay.
that in the month of January 2022, the accused had asked the present complaint to run and manage the catering service, including the bar section, along with the A block building of 6 so and so, so and so, so and so. Now, by which the complainant had deposited in good faith into 2 installments, rupees 10 lakhs, so and so, so and so, and was paid to accused on 13 January 2000 at a classic hotel at Imphal, Manipur, when the accused and his family had visited Manipur, and for which the company also bear all expenses of their stay at Classic Hotel Grande, Chingmairong, Imphal, and the accused had handed 3 checks bearing account number so and so to the complainant for the purpose of recovery of aforesaid security deposit by the, in case of closure of the running of the aforesaid. Even I have admitted on 16/1, my lord. When this complaint was filed against me, I admitted that 3 checks were handed. The bona fide and honesty on my part is from day one, my lord.
Lordship,
could have
this
said that
complaint
only
is
one
after
chair was-
that
Only I could have only
they
one
have
chair was
complained
and then
regarding
I
this.
present. I wouldn't say
After
three
the
chairs.
complainant, Lordship, they have,
Honesty is from day one, my lord.
no, Lordship, after the complainant have complained, Lordship, they have complained subsequently, Lordship, that may be very Lordship. Complainant has Lordship 11 January, Lordship, and after 4 days, Lordship, 16/1, they have
Naturally, my lord.
Lordship. Apprehension, Lordship, this is mere
If
apprehension,
it is
Lordship.
handed over to me to withdraw, and if I have withdrawn, after I have withdrawn, if the complaint is filed again, naturally I'll also file a cross FIR, my lord. But therefore, all the certified copy which I have filed before the court, I'll place before your lordship, my lord. Please give me a time after election. I have to apply 2 weeks time. I have to apply for certified copy.
Lordship may look into the Lordship, whether
And in the
this
meantime,
interim
because-
protection, Lordship,
because
can be
from the
granted for Lordship
From
for
the person
so
of
many.
the page 17 and page 19, it's all mismatching, my lord. The person, the son says something, the father says something.
Lordship, he has interim protection, Lordship. At least he can appear before the IO, Lordship, and make the submission, Lordship. They have never appeared the IO, Lordship. Once the interim is granted, Lordship.
My lord, 5 times I have appeared before the IO.
No, Lordship, it is not.
Do you
No,
have the
Lordship.
record of you're appearing
Five
before the-
times. Yes,
No, I
Lordship.
have gone.
No,
I-
Lordship,
I-
only one time,
I-
Lordship.
Wait.
I make this statement. I have inquired the client. He said I have gone 5 times.
Sorry,
On
Lordship.
10 also I didn't go because every time I go, they used to harass me. Like they used to make me see it from 10 to up to 4 and only asking to
You
produce
have
the checks.
attendance.
Only asking to produce the check, which he cannot. Whenever he goes, he's asked to produce a check, which he cannot, and he'll be made to sit from 10.
This is a wrong
4.
submission, Lordship.
It's
They have
like that
never
also.
appeared, Lordship.
Because there's nothing to because it is impossible to produce the original check. So a certified copy can be obtained from the particular court so that I can place.
Why don't you present the same copy of all those records before this IO also?
That
It's
also,
showing that it cannot be produced.
that also can be done.
Under this situation.
That also can, because therefore,
And
because
and
no,
then
my
with
lord.
with
My
the
lord, I
records,
have after
you're
going to
showing
the-
your attendance before the
Yes,
IO.
after going to the entire document, I have come to know that unless a permission is given by this honorable court, I cannot produce this photo still. At least a permission is required from this honorable court.
For that, you don't require any
No,
permission
because I'll be
presenting before
submitting
the IO.
Lordship,
Because I'll
that's
be
why,
submitting a
Lordship. They only
photocopy, my lord.
misusing
No,
the
no,
interim
this is the check.
protection, Lordship. That's
No,
it, Lordship.
No,
My
the
humble submission
document
is-
showing the IO.
No, my lord, my humble sir, I'll be submitting a photocopy, not the original.
No.
Why they need
You
to
will be telling
produce this to the court,
telling
Lordship?
them
Yes,
it-
Lordship.
It is in photocopy only because original cannot be deposited because it is before the another court.
That too, I have already made my submission in the court also. ma'am. I have already made my submission in the court.
Okay,
Okay.
Mr. Mr.
MG Singh.
MG Singh, and counsel for the petitioner. I have also heard Ms.
Lordship, this is the last, Lordship, the IO, Lordship, the status report, Lordship.
Learned additional PP for the state of Delhi. So, the learned counsel for the petitioner. What is this?
This is the last, Lordship, order, this is the last IO's, Lordship, statement, this status report, Lordship. Informed that the alleged accused, Lordship, did not submit, Lordship, and it is in the custody before, and then out of 7 number 8, and he did not comply, Lordship. He did not, Lordship, appear before the IO, Lordship. This is not only, Lordship, past several occasions also, they did not appear. They only appear before the court and seeking the time, Lordship. They extending the time period, Lordship. This is the only, Lordship, they are misusing the interim protection.
I-
What is this?
This is also the earlier occasion, Lordship. They have failed to appear before the IO. Please the scanned copy of the status report and the CD lawsuit. My submission lordship, let the lordship, this interim protection may be vacated lordship. This is high time lordship, they have only misusing the interim protection. They could not even appear before the IO and make the submission before the IO
My
lordship.
lord, I'll produce the photos. Whenever I appear, I should take photo because whenever appear, I have appeared 5 times. I have got photo of that, my lord.
They should have
And
taken that
nothing is
photograph
recorded.
to the IO
Nobody
lordship.
asking
Why
me
they
to
have
report
only
it only,
tried to
which I
submit
don't
before the court?
Could it, submit one attendance, acknowledge my appearance, so that way.
But they are not cooperating. Only I have to take a photo that I am in that police station. Look, the condition is, and now on the last occasion, they are asking me to give a power attorney,
the
which I don't
police-
have. Every time they are
The
giving.
IO is saying that you are not.
Yes,
complying.
yeah, and my lord, I'll give you the text message also. IO is sending in text message also to me, my lord. The only thing that they are asking me again, documents which I don't have. They are again forcing me to produce power attorney which I don't have. My lord, it's something impossible, and for that,
That is what I am saying. Could you produce the document showing that the document which he is seeking for, he is looking for, is before the another court.
I can give photocopy of the check, not the power attorney. I don't have power attorney also, my lord. Because when it was all in understanding. I was the ex-manager, it was all understanding, not under the power attorney also, my lord. It was a mutual understanding. We have got a friendship for the last 5 years, my lord. Now, from where I'll get a power attorney. And now the question of power attorney is also not raised by the complainant. It's only raised by the IO. Only impossible things are asked from him, my lord. So therefore, I can submit before this court and before the IO the certified copy of the case which I have filed at Imphal, my lord. And unless I'm not
Lordship,
protected,
there's ground for rejection
can
of
I
this
submit
interim
again that?
protection lordship. This, I have prayer lordship, let the lordship interim protection may be vacation lordship. And lordship, he is afraid, lordship is still evading the OS lordship. He can do lordship. He can do it better lordship in the days to come also lordship. Let the lordship interim may be vacated lordship. And the investigating team may do their own course of.
Petitioner submits that out of submits that 2 checks, 2 number of checks. Which the petitioner has been directed to deposit. The 2 numbers of original check, which the petitioner has been directed to deposit before this court has already been. It was seized or you just deposited?
I
That-
deposit.
Okay, deposited before?
Before the court.
Before which court?
Chief Judicial Magistrate.
Before the Chief Judicial Magistrate in file, in connection with which case? Case number do you have?
This model, I don't know, but after it was 100, it was under 156(3).
In connection with number, Yeah. And hence, the original check and the original check of the said and the original check of this said 2 numbers of check would not be possible to deposit before this.
It is in criminal miscase investigation.
Criminal miscase investigation,
Case number 3 of.
case number 3 of
2024.
2024.
That is CGM Imphal West.
Before the CGM Imphal West. However, we praise that certified copy of the said check as well as the complaint, as well as the complaint petition filed before the Laneb CJN West, Imphal West. Praise for allowing him to deposit the certified copy of this two check as well as this Imphal case number so and so before this court.
Lordship, my objection may be
So,
recorded
to-
also.
To show that with a view to show that the said check, the original of the said check cannot be presented before this court or the eye of the case, present case staff. So in the, by filing this case, what you have prayed, only modification. So that will be modified only after filing, that after certified. That will be taken up thereafter.
I'll place one copy to the IO, I'll place one copy before your lordship.
The
Then-
petitioner is allowed to file, you will file by way of affidavit, additional IA. That document,
That can be the IO, that particular thing I will file by way of.
okay, by filing, by way of IA, stop. The prayer is allowed, the petitioner.
Lordship,
The
my objection may
petitioner
be recorded
is
also,
directed-
Lordship. My objection may be recorded, Lordship.
Okay,
I may be allowed to file by way of affidavit.
by way of affidavit. Affidavit, The Laneb additional PP. Miss L. Hages submits
Objected,
the-
Lordship.
the petitioner by
They failed to appear before the IO, Lordship.
but on the plea of one region, one or other region, the petitioner is extending to plea with one or other region or the other. The petitioner is not complying with the order of this court. Nor cooperating with the IO of the case, hence the interim order, hence pray for vacation of the interim order, interim protection given to the petitioner. Stop. Okay.
It is a last day, maybe it's a last chance, maybe, Lordship.
Counsel for the petitioner.
Lordship.
The petitioner is, the prayer is allowed, the petitioner is directed to file the state documents by way of filing IA. Within, IA, within 2 weeks from today.
No further extension of time, Lordship.
Failing which the appropriate order shall be passed.
Lordship.
List this matter.
Lordship, 24, the 25,
Okay, on 26, this matter on 26. Okay, till, till then, the interim order shall continue.
In the meantime, they may
Shall continue.
appear before the IO, Lordship. In the meantime, Lordship.
Those, that is, I'll place one place before the IO.
Same thing you can do the IO, and then while appearing before the IO, can go with the one attendance and then obtain a signature acknowledging your presence before the IO, that will show that you have been.
Only I have to take a photo, that's not, no, I'll only place, if video losses permission, I can place a photo.
Lordship, may I, Lordship, submit, Lordship, on the, those next occasions, I maybe produce status report of the.
On which date the additional PP will produce the updated sheet?
Lordship, obliged, Lordship.
Yes. This is also AB. Whether the accused person has been arrested,
No. no.
IO made any endeavor to arrest them in the meantime?
Yes, they are absconding.
Hmm?
They are still
Absconding.
absconding, yes.
How many of them you say? It's six.
But they are named in the written.
Okay, named FIR are only six. So what that status says? They are absconding.
Yes, there is if AV is granted, there is a chance of breach of peace and tranquility. Because this is a political party worker, there are rivalry between political party workers, NCP and BJP. And these accused persons are BJP workers who has beaten the NCP workers. So there is a, this is an ongoing process of election now is coming. So there is a chance of breach of peace if granted. That is status 6.
And breach of peace in case they are arrested or in case they are not.
They are not arrested.
They are not arrested.
Yes.
You say that they are absconding. Can't.
Yes, they are still absconding.
Hmm.
I'm objecting the granting of AB to the accused persons.
Whether their involvement, has the IO recorded statement of some of the witnesses?
Yes,
Has any one of them stated giving incriminating material against those absconding accused?
there are altogether 8 complainants.
Hmm?
There are altogether 8 signatories on one FIR. And all the statement of the complainants have been recorded. Name accused in the FIR.
So this 161 is only any independent witnesses other than the informant? Independent with any recording of the statement of any independent witnesses?
Not
Have you
yet.
found? No,
Not yet.
only the informant.
Yes. 9 informant out of 9, 8 statements have been recorded.
anything, weapon of offense recovered from the place of occurrence, etc., anything
Yes, two gypsies
belongs to?
belongs to this uh, informant party. Found abandoned. It was taken away by the miscreant, and it was found abandoned in the jungle.
Taken away by this
Yes, accused, and but
accused. From where it was recovered?
from jungle. Later on, it was recovered from jungle.
Some other place.
Yes,
Okay, they have stolen this vehicle also.
yes. That's why section
That is difficult. If they started disturbing the
That's why
candidate,
section
other
3
candidate, it will be
395 also there.
395.
Yes, snatch away the mobile phone also.
That becomes difficult.
This is a political rivalry.
So that is why I'm saying political rival maybe, but then you see stealing of the vehicle belongs to the.
No, nobody steal it. That is only an allegation because there were luxury people. Because in the
Where do we find the recovery?
Recovery.
Recover and seized.
Yes, last paper, last page. This is application for
Format for requisition. Okay. See, the vehicle belong to the other party and one party taking away, vandalizing and taking away the vehicle also, it will become a difficult.
No, your I need to submit here. They themselves can say this SP was present at a particular time in the complaint.
But you see, but then this vehicle was,
And they said around 200 huts and goods.
so what? SP was present.
No, my presence, I was not there. Only they had taken this, they had not said that it was me who had taken away their gypsy or we had taken away their mobile phone.
Hmm.
May I read the complaint here?
Yes.
It's in page number.
Just a minute. Just a minute. Huh? So where is the have the IO prepared a seizure list, seizure memo of the vehicle recovered from the jungle?
it was not
regarding
in the
this?
because
This
yes.
is Jima. Where is the seizure memo?
it was not in the record.
It's there.
Not in the record.
It is taken from them also.
Anywhere the IO has the IO stated that it was seized from the jungle. Anyway,
Yes, in status
status.
from second page and third page.
Causing damage. So this abandoned vehicle, damaged and taken, was missing, was found from the jungle area of Jona village. It will be difficult. It has to be fair. So one accused is, what is his name?
His name is
Chow Seng Manche.
He appeared before I.
Whether has he been arrested?
Yes, on released on personal bond. His contention was that he was not present on the spot.
He is also named accused in the FIR.
Yes,
Okay, so he was not found involved. Personal bond, see, appearance, if nothing was found, they will be released on personal bond only. The another also, the Ahimsa Manche, Pengman Ocha, these are still absconding. So they are objecting granting pre-arrest bail.
Why I am praying for pre-arrest bail because election is coming.
So,
obviously there is a case against them.
yes, there is a it appears there is a prima facie case against, but
Yeah, there is many direct allegations against us, except the allegations that we laid the team of 200 thugs and goods. So actually who had caused this damage and who explains it, they have not said it. So this is an election style. So anybody goes anywhere with the group.
but bringing the group
No,
against another group
this
and
is-
damaging, causing hurt,
No, we have
damaging
not
vehicle,
bought
taking
any-
away vehicle and the mobile itself, which you see.
No, this is not the allegations that we bought that goods and we attacked them. May I come to the complaint? From the complaint, it is very much clear
Hmm.
that it is not us that we attacked them. Because there is a political rivalry, something might have happened that cannot be ruled out. During campaigning or something, some arguments might have occurred.
That is what I am saying.
So it is not that we intentionally blocked them, targeted them, damaged their vehicles, or snatched their intentionally, because intention has to be looked out. Because here, political rivalry, we are the main workers of BJP teams. That is the reason why they have put our name specifically, even though we were not present, because some of them are not present also. So that if they block us, then the campaign will get hampered, and our right to franchise our votes will be curtailed.
Because when you followed and thereafter intercepted.
Intercept, yes.
And things happen. So this is not a good sign for the democratic, in the democratic
It
country.
was not intercepted by us. It is allegation that we had intercepted. It is not by name.
Because now due to political
your party, and then out of these peoples, you 6 or 7 of them have been identified. And otherwise, so many people were there. And
No,
then this is,
we are identified, our name is there because we're active workers there. No, Your Lord, we were never present there.
the other persons who were present along with these active workers.
No, we were not present. Some of were at Kansai. If anything was offered at Manmo. I'm till next date may be given. On that date, this may be said, I'm ready to give statement, cooperate with the investigation, even I'm ready to furnish the bond, not to disturb law and order situation. And that till the election is over. I will abide by all these rules and regulations that are known. I'm even ready to furnish the bond over there, to keep peace and tranquility in the area. Because if I am arrested now my right to franchise vote will be curtailed here. This is the other way around to put and pressure so that I cannot just vote.
It is not a case that the incident didn't happen.
Incident because there is,
Incident happened, that is why it is happening.
but we
So
were not,
how it is that, how you can say that this is way to control? No.
incidents happen, that is because even they had narrated SP was there. He was
SP, how the SP, even if he is present also, about 200 person, how he can control? Not possible.
no, it's not.
If SP was there, doesn't mean that you did not do anything.
Even in that outward bully,
Hmm.
even we cannot control them. Because even we ask them, somebody will throw stones from somewhere, because 200 persons, because it is not me who has directly thrown the stone. It's not that allegation that we started throwing stone, then followed by the other 200.
Yeah.
Because had that been
That is
case,
the allegation.
no, Your Honor. It was 200 thugs.
Hmm.
They specifically mentions a group of approximately 200 thugs and group. In the complaint itself, they had mentioned, may I come to the complaint? Your Honor?
Statements are also, thereafter statement also, they have already given statement before the
That
police.
their interest, they're 9.
Hmm.
Whereas they say in the complaint, they have not said how many persons they will say 9-10%. Though from whose snatches was done, they are not complaining at all. The victims are not complained here. The complainants are independent persons.
Okay. Take. Mr. You,
DKD.
sorry, DK Deori, Land Counsel for the petitioner. I have also heard Mr. G. Dado, Learned PP, Government Elected. Apprehending his arrest in connection with Namsai PS case number 26/2024 under section 325, 395, 427, 507 of the Indian Penal Code. The accused applicant filed this bail application under section 438 of the Code of Criminal Procedure, seeking pre-arrest bail. Accused is Cho Senkum Manche. After accused applicant. So, para. The case of the petitioner is that 9 person said to be a victim lodged a written FIR before the OC police station Namsai, inter alia alleging therein that on the evening of 29/3/2024 at around 11:30 p.m. a group of approximately 200 thugs and goons wearing masks, armed with deadly weapons, who is this Chow Jingmu Namchung? He's okay. Wear masks and deadly weapons, led by. But then the candidate, he is a candidate. Candidate himself is not been alleged. That he is that made. Okay, led by Sri Chow Ahimsa Manche, Sri Chow Peng Manang, Sri Chow Sihana Chotang, Chow Sangkhul Manche, Chow Chekham Manche, and Chow Miling Kankyo. And others engaged in severe assault, causing damage to their vehicles, criminal intimidation, issuing threat to life, against the worker of NCP candidate near Power Grid in Manmore. So this Chow Jingmu Namsung is a BJP. Okay, then prior to giving this name, belong to the BJP candidate, led by. Okay. So they brutally attacked their teams, causing severe injuries to them, to some of them. To Tayo is Isaac, to Tayo Isaac, to Tayo Isaac on his head, back side of the body, etc. No, to them, no need to, so many names, no need to write those names. Okay, stop. Basing on the above written FIR, the case was registered. The above PS case was registered, being Homicide PS case number 26/2024 under section 325. The PS case was registered. It is submitted that the accused persons are not involved in that. Your submission is that you are not involved.
I'm not at that particular point of time. I was not even in the place of offense.
Okay. The accused persons are innocent of all the allegations against them in the state of fire, as they were not present not even present in the place of occurrence.
The active campaigner. So that is the
And
reason
since they were active campaigner of the BJP candidate, the informant named them as an accused in the above PS case. So hence, there is a reasonable apprehension that the police might arrest them and cause unnecessary harassment. And with a view to prevent them from casting their vote, they may also be put inside a jail custody. So, hence, this rearrest them. Hence this application for grant of rearrest bail. Stop. Para. Mr. Tado Lanet, additional PP, produced a case scanned copy of the case diary as well as the status report. Then I have produced the same. No one has identified this person that they were present practically. Anyone has identified? They only said group,
Yes, led by them.
led by them. So
Around one-
identified saying that he has done this, he has done that. Anyone has stated? No.
No.
As per the basing on the records, the landed additional PP submits that out of the 7 named accused person, 6 named accused person, 1 accused persons, it is accused person named Joe Senkun Manche appeared before the IU of the case. And on examination, as he was not found present in the spot at the time of at the spot during the incident. He was released on personal bond. The landed identity further submits that the abandoned vehicle gypsy, two numbers of gypsies were found, the further submits that two numbers of gypsies alleged to have been taken by the accused persons have been found abandoned in the jungle area of Jonah village, and which was recovered and later on released on Zimma to the owner of the vehicle. So he further submits that since the group said to be the workers of the political party engaged in severe assault, causing damage to their vehicle, criminal intimidation against the workers of another political party, and also brutally attack their teams, causing severe injuries to some of the workers of the informant's party. And also damage and taken away the vehicle. Two vehicle belongs to the informant's party. There is every possibility that the same group, if not arrested, may commit similar type of offense, leading to a breach of peace and tranquility during the ongoing election process of simultaneously parliamentary and assembly election 2024. As raise objection to the grant of interim anticipatory bail to the applicant. So, considering the submission made by the parties and on perusal of records, I'm of the view that no, just a minute. Since the matter is still under investigation, and the IO is yet to record the statement of some of the victim and the witnesses, the I'm not inclined to interfere. with the investigation of the case at this stage. Accordingly, the matter shall be decided after the matter will be listed after 3 weeks with the updated schedule. Stop. In the meantime, till then, as an interim, in the event of arrest of the accused applicant in connection with the above NAMSA PS case number 26, 2024, 325, 427, 9, 395, 506 IPC. He shall be released on interim anticipatory bail on execution of a bail bond of rupees 50,000 with two surety of like amount to the satisfaction of the IO of the case, with further condition that number 1, that he shall make himself available for interrogation by a police, by interrogation by the IO as and when required, that he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officer, that he shall not commit the similar nature of offense against offense as he is alleged of commission of the said offense. So he be directed to report, or just that will do condition?
I may be directed to report before the IO. 2 or 3 days.
Okay, the first condition that he shall report before the IO of the case within a week from today. Within a week from today. Huh? Okay. Right now, in the event of violation of any of the above conditions, the interim anticipatory bail granted to the accused applicant shall automatically stand cancelled. Okay, with the above, just a minute. Huh? List this matter after 3 weeks. Huh?
Yes.
Okay.
Let it be fixed.
Okay.
25th.
Hmm?
25th.
25th. This is matter again on 25th. Okay.
CD may be written. CD may be written.
Return the CD with the direction to produce updated CD on the next.
On next.
So, only one.
Item 8 to 13 are arising out
8
of
to
same
13 will be the
same FIR.
Will be same, huh? 8 to 13, same condition. Only name change, number change 13, huh?
Bail application number and name will be
Okay.
there.
have any objection? Mister? Your name is there?
No, my lord. I'm appearing on behalf of M. Kato.
Appearing on behalf of Mr. M. Kato, Land Counsel for the petitioner. Also have Mr. Land Counsel for the respondent. My name is there. Appearing on behalf of Mr. P. Party. Land Counsel for the respondent. Staff. Is prayed for by the Land Counsel for the parties. List this matter after
2 weeks, my lord.
2 weeks. Okay.
Highly obliged.
Okay. 14, I think, John, no? Yes.
May I, my lord?
Hmm.
My lord, I'm for the petitioner and the conducting council is out of station, my lord.
Okay. You are Mr.
P. Sitting, my lord.
Your name is there?
No, my lord.
Okay. Appearing on behalf of Mr.
L. Perme.
L. Party. When do you want, you said?
After 3 weeks, my lord.
Okay. Praise for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, my lord.
May I, Lordship?
Yes.
Lordship, here, service report is still awaited, Lordship. Earlier interim shall be continued, Lordship.
Part Miss.
R.C. Lawangcha.
Land Counsel for the applicant. No. CRP
Petitioner, Lordship.
for the petitioner. Oh, this is 15. Okay. The office note dated 9/4/2024 reflect that the service report in respect of the sole respondent is still awaited. Stop. In view of the above, list this matter after 2 weeks.
After 19.
After?
19th.
Okay, 19. That is after 2 weeks. Okay.
Obliged.
Yes.
Yes, may I please your honor.
Yes.
Here is the one IA that is for IA is regarding the condonation of delay.
Okay.
Delay was not yet condoned, so 104.
Who is for the other side?
Other side is my.
You have any objection? In corner. So,
There are 6
file
I have.
objection. Have you filed objection?
No.
Okay.
My ground is only the medical ground. Para 6 I have cited entire. No?
Para 6.
Yes. Paragraph 6.
Yes. What is that?
This is the appellant fell ill for some months, for which he has undergone treatment, for which
How delay of how many days, by the way?
131 days.
131
days. Yes.
He was under medical treatment.
Yes. I have annexed the document also, the treatment document, and B.
This is second appeal.
Yes, second appeal.
Yes. The ground for condemnation of delay of 131 is not a. Let us see there are six. There are six. Yes. Before filing, there was second appeal. The applicant was suffering from different ailments and underwent medical treatment in the hospital allopathy since 1 year days, but no sign of improvement and all on sudden. The applicant becomes serious from the month of February 2023, for which the applicant changed medical treatment from allopathy to Mensi-Khan, Indian medical and Ortho Institute of H. The Dalai Lama, branch at Siddhartha Vihar, Italy, from the month of February 2023. This is the ground for condemnation of delay. Now here I don't find that he was taking treatment as an input basis. And the appellant is residing at mode 2. If she can go to Siddhartha for medical treatment, he could have come to court. So this is not a good ground for condemnation of delay. And in the appeal, usually certificate is given by the counsel of the appellant. Her appearance in the court is not necessary. So the ground that has been given for condemnation of delay is not a good. So the trial court decided case in your favor. Yes, in both. And the first appeal also. Yes. I think here also you have a good chance. Give her a fair chance. Delay on delay. You say again on delay. Causing trouble would not help. And then since you have a good case. Harassment. It won't be more harassment than that one. I think a fair chance can give him one chance. It's hardly a question of a. But she is found to be old lady, and then treatment, probably there may be some other problem also.
Yes.
Because of which she could not, which may of course not be, of course, she might have not stated here. Okay. Third, planning counsel for the applicant, Mr. M. Bhatt. Also, Mr. S. Koyam, planning counsel for the opposite party. Start. This is an application under Section 5 of the Limitation Act 1963, praying for condonation of delay of 131 days in filing the connected regular second appeal. Stop. The the ground for not filing this appeal on time has been stated in paragraph 6 of the condonation petition, inter alia stating that the appellant was suffering from different ailment, and she was undergoing medical treatment in the hospital under medical treatment in the hospital within bracket allopathic since a year back, and is there was no sign of improvement. She had to shift it. No sign of improvement. And on suddenly when she becomes serious, from the month of February 2023, she had changed medical treatment shifted her medical treatment from allopathy to Men Si Kang, within bracket Tibetan Medical and Arthro Institute of HH, the Dalai Lama, within bracket, at Siddharth, branch at Siddharth, Bihar, Itanagar, to till that, due to which there has been a delay of 161 days. So 131 days in filing the connected second appeal. The learned counsel for the opposite party fairly submitted that although the region's ground stated by the applicant is not a good ground, but however, for end of justice, a delay if condoned, he has no objection if the delay is condoned for an delay of 131 days is condoned. Stop. In view of the above, submission of the learned counsel parties, I am fully satisfied. Prior to that, prior to the submission of the respondent, I am fully satisfied. The ground for not filing the connected appeal on time due to the reason stated above. And thereafter this, okay. In view of the above, the delay of 131 days is hereby condoned. Stop. With the above, this IA stands allowed and disposed of. Stop. I think the RSA has already been registered.
Yes, already registered. That is 06/2023.
Okay. So here, how many respondent parties are there? Two. Okay. Para, hard both, same, in view of the order pass today in IA 104 AP 2023. This appeal is admitted for hearing. The stop. Since Mr. S. Koya appears and accepted notice on behalf of the respondent number 1. You are for
One and two.
1 and 2.
Yes.
Okay. 1 and 2. No formal notice need be issued to the respondents. You require extra copy?
Yes.
Not required. Okay, stop. Call for the LCR required,
Yes.
required.
Before calling of LCR, I think substantial question.
Substantial
has
question
to
of-
be there.
Hmm,
Thereafter, I think.
just a
required.
minute, huh?
Yes.
The have you seen the substantial question, draft substantial question, Mr. Koyan? Have you seen or not seen? Ah. Hmm. Okay, so, okay, then in the second paragraph would be the appeal is admitted on the following for
Page 18, I am given there.
the appeal is admitted for determination on of the following substantial question of law. In page 18 it is there, huh? So just see one the page 18 once. Is it okay? Or you want hearing? If you have one hearing. So he hasn't gone through, then I think one chance can be given to him, fair chance can be given to him. Let him also go through whether this is a substantial question to be admitted or not. Because this may be, because second appeal, it has to be on the substantial question only. So let him go through, and if there is any objection,
Then in that case, in a very short date.
okay, so that, then leave the other, huh? Then the least is matter after 2 weeks.
Otherwise, it will. Otherwise, it
After
will-
2 weeks. Okay, that is fair enough.
After election, after
After 2
19,
weeks.
after 19.
After 19 is
Yes.
2 weeks, after 2 weeks. That will be only after 20 plus, that will be only after 20 plus. 3 weeks.
Then matter may be fixed as a fixed date.
When do you want that?
On 2nd May.
Okay. He is prayed for by the Lana Council for the party. List is matter on 2/5/2023. Yeah, 24. Huh? Okay then.
Oh, all right.
Yes, Your Lordship.
Yes.
Steps upon, service report on steps taken on respondent 1 and 2, still awaited.
Yes. It was, Ms. Ndangan, Lana
All-
Council for
Petitioner.
the petitioner. So, other side is represented by no one.
No one, they have not
Okay,
appeared
no one
yet.
appears on behalf of the respondent. Sorry, service still awaited, only one,
Two
two,
respondents.
okay, just, Dangan, huh? The office note dated 9/4/2024 reflect that the service report in respect of us, both the respondent number 1 and 2 are still awaited. Stop. In view of the above, list this matter after
2 weeks, Lordship.
2 weeks.
Interim order partially may be
2
continued.
weeks. Stop. Para. Interim order passed earlier,
11/1/24.
passed on 11/1/2024 shall continue till the next date. Okay.
Obliged.
Yes, Mr. Singh.
Lordship, the judgment is, Your Lordship, at page 18 onwards, Your
This
Lordship.
is filing this for the first time.
Lordship, this is
It
the
was
first-
already there, or
Lordship,
okay. So which one so we should take a favor?
Lordship. This is an appeal, Your Lordship, preferred under section 47A of guardianship and ward settlement. Against the judgment and order dated 19/3/24, passed in guardianship application, Lordship, Got
Just
it,
a minute, huh?
Lordship.
Judgment, which you are reading?
From page 18 onwards, judgment is annexure 1. Lordship, got it?
Just a minute. Huh? Mm, 18. Page
Onwards. 18, page 18
18.
onwards.
Okay.
And the relevant portion, Your Lordship, I will take directly to
This is about guardianship.
Lordship. Page 33 is the relevant portion. After perusing the petition,
Just a minute. Huh? Relevant is?
relevant is page 33. This is an order.
33.
Decision starts from page 32, last paragraph.
Yes.
Page 32, last
Yes.
paragraph. Decision starts from paragraph 45.
Yes.
Therefore, on the above reasons, perusing the plaint along with the annexures, the citations, and taking into consideration the welfare of the minor child who is at a growing stage, it is felt necessary that the applicant be given the custody of the minor child. Therefore, both the points for determination are answered in affirmative by holding that the present suit is maintainable and the applicant is entitled to custody of the minor child. Next paragraph orders, after perusing the petition, the annexures, and after hearing the counsel of the petitioner, the court finds that the applicant has been able to make out a case. Therefore, the custody of minor son, namely Charu Jarin, is given to the applicant by appointing her as guardian of the minor son under Section 7 of the Guardianship and Wards Act 1890. And the respondent is hereby directed to hand over the minor child to the applicant within 2 weeks from today.
Yes.
The minor child is still under my custody, Your Lordship.
Your husband.
No, Your Lordship. I am uncle of the minor child.
What about, what is the just brief of the case?
Lordship, here the brief of the case is that here the applicant, before the learned court below, was the biological mother of the minor child. And during that period, Your Lordship, what happened, the husband of the present applicant probably has assaulted the present applicant. For that reason, she was admitted in hospital for a long period of time. And in retaliation to that assault on their minor sister, the brothers of the present applicant has
Not present
killed.
applicant. Brother of the applicant.
Yes, brother of the present applicant has killed the father of the present minor son, which I have also annexed the copy of
The
the
present
FIR.
applicant is the father side only.
Lordship,
Present applicant
yes.
herein is the father of the minor child.
In the appeal, yes.
Yes. So
No, he is not the father.
no, uncle of the victim.
Uncle of
wife.
the minor child.
Uncle of the minor child from the mother side or father side?
From the father side.
Father side.
Lordship.
So that is how I think you just clarify how the brother of the applicant will assault.
Yes, that is the reason was that here the applicant likha.
No, the applicant in the court below
Lordship.
was hospitalized.
Yes. In
And
retaliation.
then while she was, since she is a victim,
Lordship.
her brother side
Yes.
has assaulted the
husband of the present applicant,
Yes, husband of the present.
Charu Tanu, yes.
No, present applicant is the husband side only. He is a brother.
Huh.
Why the husband is not coming in the picture?
No, husband is no more now, Lordship.
Oh,
He was being killed by the brother of the present applicant. Here sorry, Lordship,
no.
he was being killed by the present applicant's brother, Your Lordship.
Okay, brother. That means the
Because of that reason, during that intervening period, the minor child was under the custody of present appellant, Your Lordship.
okay. So she claim for the custody of the child. How many children or child? One.
One.
Okay. What is the age of the child?
It's around 8 to 10 years.
8 to 10 years.
Lordship.
So it was with the uncle.
Yes.
But on this uncle side, the present applicant side has assaulted the mother.
Husband has assaulted. Here the
No,
present.
you say the husband is no more.
Yes.
How the husband is assaulted?
No.
Let us read. Just
Lordship, kindly, I'm trying to understand, Your Lordship. Here the applicant before the learned court below and present the respondent is Charutada, Lordship. Is the respondent. Now the wife, here clearly mentioned, the wife of late Charu Tanu.
Who is Chartanu?
Charu Tanu is the husband of Likhayakam, who is who was the applicant before the learned court below. Now, Likhayakam's husband was killed by the brother of the applicant Likhayakam.
Oh, brother of the applicant Likhayakam.
Yes, before the.
Okay.
That FIR and the charge sheet also have annexed here. Because of that reason, taking into account the safety and security, even of the minor son, the present uncle took the minor child to his place. Now, the minor child is staying happily under the custody of present
Killing
appellant.
was due to the matrimonial disputes or for some other reason?
There was a matrimonial dispute between the husband and wife.
Okay, in connection with that, he was killed.
Yes. Not killed. Thereafter, Your Lordship, another issue arises in retaliation to the assault made by the husband of the present applicant, Likhayakam, who is the respondent here in the case. They have killed.
Assault to whom?
Assault to the brother. Assault to the brother of the present respondent.
By whom?
By the respondent there, Likhayakam's brothers. Likhayakam's brother.
No, respondent there is the, would be you, because Likhayakam
Yes.
was a petitioner there.
Yes, yes.
Petitioner or by the brother of the petitioner or respondent?
Lordship,
Clarify, brother of the petitioner or the respondent?
there,
In a tribe.
at brother of the applicant,
Okay.
here they were the respondent's brother.
Okay. Have you given a synopsis also? No.
I have that's the gist of the case.
Where is the gist?
Synopsis is at page 1.
No, not synopsis. We have already given. Have you given synopsis?
Yes, I have given. Page 1 itself. After the index.
Okay.
I prefer this appeal.
Yes, just read. Let us read. Whether the minor son was examined before the court. Court
Yes.
has asked-
That order also I have annexed, your worship. He was counsel. But on both the occasions, he has refused to stay with the mother. That was the main concern of the present appellant, your worship.
But then you see, since the child is minor, that is below 7, 8, the
It was
mother
that-
is entitled otherwise.
I am not at all disputing, your worship.
Hmm.
That is, even today also I am ready to hand over the custody, taking into account the seriousness of the case and the safety and security of the minor child. Apart from that, he is
What safety and security, what danger the son will face with the mother?
the brother of the mother,
Hmm?
brothers of the mother.
But maybe some other reason, but then this is son,
Uh,
son of the applicant.
Yes,
Hmm.
I'm not disputing, your worship. I'm not at all disputing.
Then-
She is a biological mother. I'm not
Yes,
disputing.
then the son is always, or child is always safer with the biological mother, safest place in the world for the
But the
child.
surroundings, for that, your worship, the surroundings is not at all safe.
Surrounding. you
Apart
see,
from that
may
also-
be- that is why I was asking,
Worship.
that what was the reason? Was it a matrimonial dispute or was it something else?
The
for
surrounding is,
cause of murder?
the surrounding is not conducive on account of the present
No, no.
respondent's brother.
Even the son would never be happy. Will the son be happy by staying away from the mother?
I'm not at all,
Then
I'm not at all denying the I've never said that I will not.
unless you prove
Worship.
unless you prove otherwise, it's always with the mother only. The child has to be with the mother.
But the minor child has shown his unwillingness. Your
That is
worship.
because you see, the mother was
Not only once, on
mother was
3
in the
occasions.
hospital, and then this was with the child was with this uncle and all.
Lordship.
So that while bringing in the hospital in the court before the court, then it's when it was the child is with in the custody of a person, then automatically that influence and that possibility is always there. Okay.
Because I'm still ready.
Where
to-
have you annexed that one? The
Yeah.
child stating that he wants to stay with the uncle?
No,
not
that
with the
statement is not there, but produced before the honorable court, your lordship.
No.
It was counsel.
Okay, it is not annexed here.
I have annexed at page 56 and 57. Even today also, your lordship, I am saying, if the child shows his willingness to stay with mother, I have no any objection. Even this honorable court can also direct the appellant to produce the minor child, your lordship. That I am agreeable, your lordship.
In that case, to examine that, the mother and the uncle need to be present
Lordship.
in the court, physical present, and then can be asked in the chamber. So that can be done if required. But for the time being, no, it's only hard the child.
Lordship, thereafter, the court has also given
No
counseling
order,
to
no
minor.
order. Where the statement of the child?
Page 56, your lordship. The orders passed by the learned. The court has given counseling to objector and half elder brother of the minor in the presence of counsels representing respective parties. The court has also given counseling to minor. In the circumstances, hearing on final argument is adjourned for today. The objector and his family members are directed to meet the minor and take him with her, if the minor so desires. If the minor so desires, Your Lordship. List the matter again on
No,
27.
where is it, where you said, you have just stated that the minor has stated in favor to not, that he don't want to stay with the mother. The minor is a boy or girl?
That was before the honorable court, Your Lordship, in the chamber.
Not on record.
That has not been, in the next paragraph.
Then why you have submitted?
Lordship, I am.
You said that
still-
minor expressed his willingness to stay with the uncle.
That was the main ground, Your Lordship. That was the main ground, that was not at all considered. Next page is also, heard the minor child in the chamber. Nothing
Where?
has been
Next
mentioned.
page is where?
Page 57 is the next order.
There also nothing has been indicated, only heard. So where is the record?
Child was
statement.
produced in the chamber, not a single
Whether the
counsel.
minor has stated in the, before the court in the chamber? And
Yes,
express his willingness to stay with whom he wanted to stay with?
with the uncle, present,
Where
present
is that?
appellant.
Where is that?
That is not mentioned in the order sheet.
No, where is that order? Where is that order which has not been mentioned in the order sheet or in the judgment?
Lordship,
Whether the statement of the child has been reduced into writing in the order?
no.
Okay, then on what basis you are submitting?
There are something which, even Lordship, Lordship can direct the minor child to produce before this court also, Lordship. I am ready to produce.
Yes, what?
This honorable court can also direct the minor child to produce, Lordship, before this honorable court. Lordship can counsel
If
also.
required, that will be done if required.
Because he has clearly shown, I have stated in my petition, even objection also.
So after this order, whether you have handed over the minor child,
Not yet, Lordship.
Not yet.
We
Why?
have filed this,
you
Present
were
appeal.
directed to hand over the child within how many days?
within 15 days, Your Lordship.
Why you have not submitted? Why they are not?
The presently,
Given the
they were, there was a talk between the parties, Your Lordship. They have, the biological mother has called. So during that period, the present appellant is at his hometown. And apart from that, this appeal is also being preferred, Your Lordship. In paragraph 23 of the judgment, Your Lordship. Paragraph 23 of the judgment, Your Lordship.
Okay, during the pendency of the complaint, case on so and so, the petitioner late husband. The mother was in ICU,
Yes,
so now she's Has he come out or? Yes, what is there in page 23? Para?
Page 23, it says that the respondent,
Para?
Shri, para 23, page 25, para 23.
Okay, she is also working. Okay, the respondent under whose custody the child is has 2 wives and 5 children. Para 25.
Para 23, page 25.
Yes, what is there?
The respondent Charu Tata submitted his written argument and stated that at the present he has strong objection on giving the custody of the child to the applicant. However, after attaining the age of 18 years or as on when the minor wants to, as and when the minor wants to stay with the petitioner, the respondent would have no objection. That on 2 occasions the minor child was produced before this honorable court, whereby he was counselled, and thereafter the custody was given to the respondent, your lordship, on account of refusal to stay with the mother and go with the mother. As the minor child has shown his unwillingness to stay with the mother, that under the circumstances, if minor child is forced to stay with the petitioner, despite his unwillingness, that may amount to psychological effect damage on minor child, your lordship. This was also.
It's a submission only. This is submission only.
Lordship, this was,
This
I have
is the order
stated
of the-
because it was counseled, your lordship, on 2
this-
occasions.
This is submission.
Yes.
Okay.
And apart from that, section 17(5) of the Guardianship and Wards Act also specifically mentioned that the court shall not appoint or declare any person to be a guardian against his will.
So, what can be done at the time?
Lordship,
Moment.
notice may be issued, records can
What
be
is
called
this
for.
IA for?
IA for suspension of the impugned judgment, your lordship.
Will issue notice?
Lordship.
Mr. Singh, land counsel for the appellant. This is an appeal. This is an application under section 47
Lordship.
A of Guardian and Ward Act 1890 against the judgment and decree dated 19/3/2024 passed by the learned district judge Papumpare in guardianship application number 16/2022, whereby while allowing the said application, the custody of the minor's son, namely Charu Jari, has been given to the respondent applicant, the respondent petitioner, huh? Stop, huh? Sarah. Issue notice returnable by 4 weeks. Call for LCR. The respondent, so the petitioner, the appellant shall take steps upon the respondent, sole respondent,
Lordship, sole respondent.
by a registered post with AD within a week from today. Stop. List this matter after.
Lordship,
4
there will be holiday, Lordship. So
After 4 weeks.
within a week, no, so far as steps is concerned, Your Lordship.
That is why I'm giving 1 week.
The court
How
is
many days
going
you
to-
want?
The court is going to be open on 22nd. By 22. I will
Okay,
take step.
so within 10 days,
Lordship.
will it be okay? Today is after 4 weeks.
Lordship, did IA,
That will be taken up.
IA number 64, Your Lordship.
That will be taken up.
Your Lordship, in this case also notice can be.
Notice, yes, no, okay. Same, huh? Mr. Nicky Singh, Land Counsel for the applicant. This will be fixed. Sarah. This is an application praying for suspension of the impugned judgment and order dated 19/3/2024 passed by the Lanet District Judge, UP Papumpari District in guardianship application number 16/2022. Stop. Issue notice returnable by 4 weeks. The petitioner, the applicant shall take steps upon the sole respondent within 5 working days from today. Stop. List this matter after 4 weeks. Okay.
Lordship, what about regarding the suspension of the, because this is a statutory provision, Your Lordship.
Okay.
Let them come, Lordship, they will say.
Till returnable date. The operation of. No, we'll say the let her be present, huh? The interim prayer shall be considered.
Otherwise, Your
on the
Lordship,
next-
the
on the
proce-
returnable date, huh?
execution proceeding may be initiated, Your Lordship, otherwise.
In that
That
case,
is
you
the
make a prayer,
apprehension.
because since legally also you admittedly, you also have admitted that at this age, legally she is entitled actually. If there is,
Lordship, there are certain kind of difficulties, your Lordship. Still, I have never denied your Lordship to hand over.
yeah,
the minor child.
that is what I'm saying. You have
Therefore,
also not denied, and then you have 2 wives, 5 children,
Lordship,
and she is
similarly,
working,
it is the
she is
case of the
working in the
respondent also.
department, you are not working, it will be difficult.
No, I'm working, I'm not a government servant, I'm a businessman. Your Lordship. So therefore,
We'll
till
consider-
returnable debt only, Lordship, till returnable debt, I impugn judgment.
It will
of
be
this
difficult
suspect.
because knowing that the law is against you and in her favor, it will
Lordship,
be
this is
difficult.
statute
And
provision.
unless you show
I
something,
prefer this appeal under section 47A, statute provision. And 70A also provides solution. That is why I am saying, Lordship. Otherwise,
then we'll have to fix date.
Lordship, I don't have any.
Hmm? Hmm. Till, in the meantime, till the operation of the impugn judgment shall remain stayed till the returnable date. Okay.